Traiga la manguera, que son 45.
Cuando cumples 45, te toca soplar muchas velas y examinarte contra el cáncer de colon, ya que al detectarse temprano es más tratable en 9 de cada 10 personas. Usa la prueba de Cologuard en la privacidad de tu casa y envíala de regreso para obtener tus resultados. La prueba de Cologuard es una opción con receta para detectar el cáncer de colon en personas de 45 años o más con riesgo promedio. Resultados positivos deben ir seguidos de una colonoscopía. Pueden darse resultados falsos positivos y falsos negativos. La prueba de Cologuard no reemplaza la colonoscopía en pacientes de alto riesgo. No uses Cologuard si has tenido adenomas, si tienes enfermedad inflamatoria intestinal y ciertos síndromes hereditarios o un historial personal o familiar de cáncer de colon. Pide la prueba de Cologuard a tu médico. Para más información en español, visita cologuard.com/prueba.
This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Ever wonder why we make the choices we do and how to make smarter ones? Join Wharton professor Katie Milkman, an award-winning behavioral scientist and author of the best-selling book, How to Change, as she shares true stories from Nobel laureates, authors, athletes, and everyday people about why we do the things we do and how to make better choices to help avoid costly mistakes. Choiceology covers the latest research in behavioral science and dives into themes like the power of self-control, shaping your mindset for success, navigating new beginnings, and why starting over can feel so hard. Listen to Choiceology at schwab.com/podcast or wherever you listen. This is Amicus, Slate's podcast about the courts and the law and the Supreme Court. I'm Dahlia Lithwick.
How do you handle criticism of your court or your opinions today?
Well, it does come with the territory.
He is trying to signal to the White House and to the public, the White House won't get it, maybe the public will, that something has gone awry and that there is more than just the usual power struggle between the branches going on right now.
Personally directed hostility is dangerous, and it's got to stop.
That the executive branch actually seems to be trying to make judges feel unsafe when they rule against him, and that crosses a line that even the Chief Justice wants to police.
May we live in less interesting times. This week, an unsettling realization occurred for somebody who's reported on the Supreme Court for a quarter of a century. A kind of disorientation has crept in this term, and I confess this to reassure you that if you now find yourself just a little bit woolly-headed about the comings and goings at the Supreme Court, you're not alone, and this is the show for you, for us. Between continued shadow docket machinations, the 11th hour decision to grant cert on yet another major case cramming blockbuster arguments into the very last week of April, and the Chief Justice's gentle importuning this week to kindly be kinder to judges and justices, it is easy to lose one's bearings. But we are in the middle of an extremely consequential term. The court is being whipsawed by Donald Trump's manic activities and insults. And in the coming months, the Nine will be deciding a crop of cases that may change the shape of the country and the Constitution, with vast consequences for elections, executive power, LGBTQ rights, and who gets to be an American. And that's just the tip of the iceberg. So this week we are doing one of the things I love to do best, which is check in with co-host Mark Joseph Stern to try to wrap our heads around all of this and more. Mark, welcome back.
Thank you so much. Happy to be here. I'm a little sad that I am the person who you call upon when you need a neurotic SCOTUS follower to walk you through all the bad things they're up to. But that is my lot in life, and I'm here to do it.
So, Mark, let's start at the beginning. And maybe the biggest news out of the Supreme Court this past week was that the justices refused to allow the Donald Trump administration to immediately revoke temporary protected status, that's what we call TPS, for more than 350,000 immigrants from Haiti and Syria allowing them to stay in the country and work and live while this case is resolved. And arguments and briefing are actually going to happen. It's not going to happen on the shadow docket. It's going to happen like normal people on the regular docket. So I wonder if before we even talk about what the court decided this week, can you just walk us through the TPS program, how long it's existed, why it exists, why it matters?
Absolutely. So Congress created TPS in 1990 to give the executive branch authority to let immigrants who are already living in the United States remain and work here legally when there are dangerous conditions in their country, either man-made or natural. So a hurricane, an earthquake, or armed conflict, a civil war, all that kind of stuff that would make it unsafe for them to return. It's been used by every president since. It is one of the great humanitarian features of our immigration system, and it sort of embodies the basic idea that we probably don't want to send law-abiding immigrants back to their home country to die, to be killed, to suffer horrible things. And so we allow them to stay here for certain periods of time. A designation for TPS applies to a country for 6 to 18 months, but at the end of that time, it can be extended even longer so that, again, people who are living here and following the law, people who are not breaking the law, they can continue their lives, continue to be with their families while conditions in their home country remain untenable.
You mentioned that this program has existed. Both parties' presidents have deployed it for good reasons. What is it that the Trump administration attempted to do to TPS? And then just please explain how they legally justified this.
So today, technically, it is the Secretary of Homeland Security who designates TPS. And so that was, for a long time, Kristi Noem. When she came into office at the beginning of the Trump administration, she wanted to terminate a bunch of TPS designations for a bunch of countries, Venezuela, Haiti, Syria, among them. All places, by the way, that are still dangerous to return to, that the government warns Americans not to travel to. But Kristi Noem said, we don't need TPS for them any longer. These people have to go home. The problem that she faced, it's not really a problem, but it was for her, is that, as I said, these designations have a set time period, and some of them were not set to expire until well into Donald Trump's term. Some of them were going to last into 2026. And so she wasn't content to just say, at the end of this designation period, the program will be terminated for this country or that country. Instead, she purported to prematurely vacate the designation well before it was set to expire, and in the process to strip legal status from cumulatively hundreds of thousands of immigrants overnight. So she said, I can, with basically the flip of a switch, just strip away these legal protections that had allowed immigrants to live and work here because I don't think that they need it anymore. I don't think this country is dangerous, and asserted this sweeping power specifically over countries that Donald Trump had targeted during the campaign trail during his previous presidency as places that we didn't want immigrants coming from because basically they were filled with non-white people.
The important part of this story, just as background, is that SCOTUS gleefully leapt into this case. They did so on the shadow docket, and they did so with a thumb on the scale for Kristi Noem.
Yes. So here's the problem that Kristi Noem faced, and this one is a real problem. The federal statute that authorizes TPS does not allow the Secretary of Homeland Security to, quote, vacate a designation prematurely. It does allow her to terminate it, to say, you know, the time is up, the 18 months are over, I'm not going to extend this. But it does not say anywhere or even really hint that she can just cut off a designation well before it's set to expire and, again, strip people of legal protections overnight. On top of that, even if you try to read that power into the statute, and again, I don't see it, a lot of legal experts don't see it, but she sees it, you would still have to follow the basic rules of administrative law. It couldn't be arbitrary and capricious. It would have to be a reasoned decision-making, carefully explained, non-pretextual justifications. Kristi Noem didn't do any of that. She didn't even really try to explain why she was doing this. It was just, we don't like these immigrants. We're going to take away their legal status overnight and render them detainable and deportable. And so on two fronts, both like on this questionable power to vacate and this pretty egregious violation of the Administrative Procedure Act, this seemed to be illegal. And a bunch of TPS holders and their advocates challenged it in court. The lower courts agreed with them, said this is not lawful. and froze Kristi Noem's effort to strip away TPS. The Trump administration, through Solicitor General John Sauer, then raced those decisions up to the Supreme Court. And on two different occasions over the past 10 months, the Supreme Court has essentially overruled the lower courts on the shadow docket and allowed for Kristi Noem to strip away TPS overnight in the pretty obviously illegal way that she sought to do. It didn't explain why. These were quintessential shadow docket rulings. The justices in the majority didn't bother to give any reasons, but they froze the lower court decisions, which was, of course, very, very bad news for the hundreds of thousands of immigrants and their families who could suddenly be deported.
Mark, we talked about this on last week's Plus bonus episode, but I think there's a danger when people talk about the law, especially when it comes to lofty Supreme Court cases. And you get way into the footnotes and sometimes lose sight of the stakes for actual people. So can we lay them out? For these hundreds of thousands of people from Syria and Haiti, what is the effect of this toggle on again, off again, about whether they are going to be deported? Can you just talk about how destabilizing this has been for people who counted on temporary protected status? There's no authority to take it away from them midstream, but they have been subjected to this chaos and this confusion anyway.
Yeah, they have incredibly strong reliance interests on holding TPS for as long as the government had promised them. And when it is taken away, they wake up the next morning without work authorization in many cases, without the ability to live here free of terror from ICE and CBP agents. In some cases, they can be detained indefinitely without bond when their TPS is taken away. And of course, they can be deported back to, again, a home country that the United States government itself says is unsafe to be in. And so when the Supreme Court stepped in, this was one of, if not the largest acts of I don't even know the right verb, undocumenting people in the history of the United States. With these shadow docket orders, unexplained, unreasoned, the Supreme Court just told hundreds of thousands of people, in those cases, Venezuelans, you were here legally, and now you're illegals, and you have to go. We'll talk about this, but I think one of the worst features of those decisions was that there seemed to be no interest in all of the hundreds of thousands of lives that had been destabilized and potentially ruined. There seemed to be no concern. The only concern was for the Trump administration, which didn't even really raise particularly strong arguments on the merits, to my mind. Instead, it cited this provision of the statute that says that certain decisions about TPS are not subject to judicial review. I don't think that applies to what Kristi Noem did here. All the lower courts to decide these cases so far don't think it applies. Again, it doesn't seem to apply because what Kristi Noem did is not even permitted by the statute. But nonetheless, I guess the Supreme Court found that to be a compelling argument. And so it just sided with Trump over the cries for help from all of these immigrants who, in a better world and with a better court, would have their injuries taken into serious consideration by the justices when deciding this kind of issue as it's pending on the shadow docket.
So let's talk about it right now, because you wrote a really, I think, smart piece this week where you noted that in addition to the importance of this grant with no noted dissents and the decision by SCOTUS to actually hear this case as though there are real people with real interests and there's a real issue and they should take it seriously and not do a back of the envelope midnight shadow docket decision. This move is also, as you noted, really a vindication of one justice in particular, and that's Justice Ketanji Brown Jackson, who has been railing against the decision to use the shadow docket as a means of disposing of these cases. And she's been doing so, as you noted, in some instances, all by her lonesome. And so in addition to the sort of merits, and we're going to talk about who's going to win this case, because that's a question, but the real issue in terms of the court deciding to take seriously what looked like her sort of lone shouting into the wind, that this is not the way the court operates, something shifted.
Absolutely. I think so. I can't prove it, but when this latest round of TPS cases came up to the Supreme Court, and these involved Syrians and Haitians, again, the past ones involved Venezuelans, I had this sick feeling in my stomach like, oh God, it's going to happen again. The court is just going to silently take away these protections from, at this point, 350,000 immigrants, right, with one decision. And Justice Jackson will issue another fierce dissent and we'll all be upset, and then that'll be that. But that didn't happen. Instead, on Monday, the Supreme Court deferred decisions on the legality of this so-called vacatur of TPS for Haiti and Syria and set the case on the rocket dockets for arguments in April and probably a decision in June. And a stay deferred is really a stay denied. I mean, what that means is that the Supreme Court refused the Trump administration's invitation to freeze the lower court decisions in favor of the immigrants and to render them deportable in an instant. This was procedurally a big win for the 350,000 immigrants from Haiti and Syria who now get to stay in the United States for at least a few months longer, get to work legally in the United States for at least a few months longer, have notice that they may need to seek an alternate way to stay here, like by applying for asylum, right? There are fallback options when immigrants are given notice that TPS will be taken away. That's why Congress built these timeframes into the statute and did not give the government the ability to just take it away overnight. I mean, this was a big deal, and I think, again, just my guess, it reflects the court maybe conceding to the point that Justice Jackson had been making in those past dissents. And she made a lot of points. We'll talk about them. But the big one that she said over and over again, and this is just true, is that when a case comes up to the court in this posture on the shadow docket, at this stage without full briefing, without oral arguments, the lower courts are still actively engaged with this. The question isn't just who's gonna win on the merits at the end of the day. The question is supposed to be who faces irreparable harm and in which direction do the equities tip? Like who is going to face a more grievous injury and who has a stronger claim to temporary relief. And what Justice Jackson said, and again, hard to contest this, is that the immigrants face the irreparable injury. The immigrants are the ones who would be grievously harmed if TPS is stripped away from them overnight. And the government, the Trump administration, couldn't point to a single concrete injury that it would face, let alone an irreparable harm, by keeping TPS in place, even just for a few months longer. Justice Jackson absolutely hammered this point in her past dissents and said, again, this is not supposed to be just about the merits. We're still in a preliminary posture. We should be asking who's harmed, and here it is not the government. And the previous two times around, the rest of the court, or at least the conservative justices, pretty much ignored her. This time, though, maybe they listened because they did exactly what she had counseled, which was to keep TPS in place and then set this case for arguments and decision the right way to ensure that everybody's claims will be aired out and heard and deliberated upon properly.
We're going to take a short break. These days, I'm all about quality over quantity, especially in my closet. If it's not well made and versatile, it's just not worth it to me. That's honestly why I love Quince. The fabrics feel elevated, the cuts are thoughtful, and the pricing actually makes sense. Quince makes high-quality wardrobe staples using premium fabrics like 100% European linen, 100% silk, and organic cotton poplin. Right now, I am continuing to love that Quince lightweight cotton cashmere sweater that I ordered in the fall. It's become one of my go-to pieces. It's light enough for layering, but it still feels completely luxe. And it didn't cost what I thought quality cashmere would. Right now, go to quince.com/amicus for free shipping and 365-day returns. That's a full year to wear it and love it, and you will. Now available in Canada, too. Don't keep settling for clothes that don't last. Go to quince.com/amicus for free shipping and 365-day returns. quince.com/amicus. Friends, I am all in for the kind of self-reflection and rethinking that we do at the beginning of the year. And Blueland's products are not just about tidying things, they're also about a cleaner lifestyle by reducing single-use plastics. I've made the switch to Blueland, especially at the start of this year when I'm really rethinking my routines and trying to build more sustainable habits at home. Certified by Cradle to Cradle, Blueland products meet the highest standard of clean. They're effective yet gentle on people and the planet. From cleaning sprays and toilet bowl cleaner to dishwasher and laundry detergent tablets, Blueland's 100% microplastic-free, EPA Safer Choice certified formulas are safe to use around my kitty cat, my kids, and I love not having to choose between the safe option and what actually gets the house clean. Blueland is a certified B Corp and Leaping Bunny cruelty-free certified. Their formulas are EPA Safer Choice certified, and many products have also earned Cradle to Cradle's Gold Material Health Certificate. Blueland has a special offer for listeners. Right now, get 15% off your first order by going to blueland.com/amicus. You won't want to miss this. Blueland.com/amicus for 15% off. That's blueland.com/amicus to get 15% off. Today's show is brought to you by Vanguard. As we step into a new year, it's the perfect time for all the advisors listening to think about how to set your clients up for success. One way to do that is to level up your fixed income strategy. But bonds are tricky. The market is huge, rates shift, and risks hide in plain sight. That's why having a partner with scale and expertise matters. Vanguard brings both. Lots of firms love to highlight their star portfolio managers, like it's all about that one brilliant mind making the magic happen. Vanguard's philosophy is a little different. They believe the best active strategies shouldn't be locked away with one person. They should be shared across the team. That way, every client benefits from the collective brainpower, not just one individual's take. So if you're looking to give your clients consistent results year in and year out, go see the record for yourself at vanguard.com/audio. That's vanguard.com/audio. All investing is subject to risk. Vanguard Marketing Corporation, distributor. And we are back with Mark Joseph Stern. I think we need to sidebar just for a second now about Justice Jackson and Justice Kavanaugh, quote, sparring over the shadow docket at a joint interview they did last week in D.C. They were on stage at an annual event at the D.C. courthouse. There's no audio of this event. It was reported, but it's pretty striking that this happens on stage in front of a lot of judges and some journalists. Justice Jackson saying that the shadow docket, or as she terms it, the emergency docket, creates what she calls a warped process. And she went on to warn this, quote, "This uptick in the court's willingness to get involved with cases on the emergency docket is a real unfortunate problem. I think it is not serving the court or our country well at this point," end quote. And of course, Justice Kavanaugh, surprising no one, defended how things get decided on the shadow docket. And this event, let's be clear, is attended by lower court judges across the spectrum, including, it's worth mentioning, Judge Boasberg, who's been targeted by the Trump administration for sharp criticism, even impeachment. He's also the star of our Executive Dysfunction newsletter this week. And I want to note that because Justice Jackson's warning was reportedly greeted with enthusiastic applause. Now, we know that lower court judges are really tired of being called out for trying their best to decide things and then being spanked for getting it wrong or for not correctly applying a shadow docket order that has no actual holding or real reasoning. But the other thing that's worth noting about this little back and forth is that Justice Jackson is not just warning in her dissents. She is sitting face to face with her colleague at an event, and she is saying, this is not an appropriate way to solve problems. And by the way, every time we grant one of these emergency appeals, we encourage yet more of it. And Justice Kavanaugh is sitting there and saying, oh, it's fine, everything's fine. Saying it out loud in a room full of judges feels like an escalation.
I think so. I think it registered as some kind of escalation. And I think it's notable there was applause in that room filled with judges. I'm reminded of about a year ago when Justice Jackson spoke to a judicial conference that had a lot of district court judges. And she praised them for their courage under fire and said, I know that loneliness. You have to keep going, keep doing what is right for our country. I do believe history will vindicate your service. It's easy to forget that the fight over the shadow docket is not just a fight over these specific cases. It's a fight over just how much disrespect the Supreme Court is going to show to the lower courts as they try to do their jobs under immense pressure and constant fierce criticism and slander from the leader of the country and many of the politicians in his party, right? With an appellate court, there's multiple members, there's multiple people to take fire. Trump went up there after the tariffs decision. He complained about Gorsuch, he complained about Barrett, he complained about Roberts. But with a district court judge, it's just you out there. And Judge Boasberg knows that better than anyone. And of course, Justice Jackson was a district court judge for many years, for most of her judicial career. And so I think she is continuing to try to express the interest of district court judges and to show her colleagues the consequences of their disregard for the careful work and reasoned opinions of district court judges and where it leads. She talks about the warped process. She says it's not serving the country well, not just the court, but the country. And this absolutely picks up the themes of some of her dissents, including in the TPS cases, where she says you are disrespecting the lower courts that are the ones who are actually on the front lines of these cases. They're the most informed and best situated to figure out what interim relief should be granted while both sides duke it out. And, for her to say that straight to Brett Kavanaugh's face feels kind of incredible to us, I guess, because we don't normally see it. Even during oral arguments, when the justices criticize each other, they have these poker faces. They stare straight ahead. They never turn to each other when they land dings and zingers. But here they were face to face. And I guess it should be a reminder, she's probably having these conversations with him behind the scenes too. And that cannot be fun. That actually probably takes a great deal of courage. There's been so much reporting about how, Justice Jackson isn't tactful, right? She isn't strategic. Justice Kagan and Justice Sotomayor, they pull their punches a little bit. They try to meet in the middle. They try to be conciliatory. We all know Justice Jackson isn't doing that. And I think that has its own kind of strategic value and strategic benefit. Shaming her colleagues into doing the right thing may be one of her MOs at this point. And again, based on the court allowing TPS to remain in place for the first time so far, may suggest that it's working and she should be keeping the pressure on and alerting the lower courts, the American people, everybody who will listen that something has gone badly awry at SCOTUS, and she's not just going to sit back and let it fester. She is going to be out there alerting us to it at all times.
Mark, you're making a really subtle and I think important point, which is we've seen more than one justice on the Roberts 6 excoriate a district court judge for not somehow, amazing mind-reading abilities of figuring out what a shadow docket order actually commands and applying it appropriately. I think that part of the reason they get away with stuff like that is because they don't always sit face to face with a bunch of district court judges, right? We also saw this in the court's first run at the birthright citizenship case last year when they avoided the decision on birthright citizenship, but certainly came away disempowering trial court judges, where it's just really easy to slag a district court judge when you're not hanging out with them and you're certainly not having to answer to exactly the critique that Jackson is lifting up here, which is they're doing their best under hardship circumstances. Somehow the court has not explained the emergency, has not explained the balance of equities, has not explained the imminent harm. And then for the court to turn around and say, we did none of those things, but you suck. It's really easy to do that when you're not sitting in a room full of judges who are doing their very best. And I think one of the things that you're saying that is really important is you cannot talk about judicial independence. Again, in a second, we'll talk about John Roberts talking about judicial independence without sweeping in the entire judiciary. And it is really, really common to hear the justices at the Supreme Court who can be insulated from a lot of the slings and arrows other than the ones flung directly at them to say, judicial independence means I should be free. This was a really important moment, I think, in which Justice Jackson did exactly what you noted she did when speaking to judges last year, which is say, I see you, I hear you, I know you are part of the Article 3 judiciary, I know that the work that you do matters, and I understand that when we of all people on this court attack you or allow others to attack you, we are failing to do our job. And I think it's an important move, and I'm not sure we hear it as much from members of the Supreme Court as we should.
No, I agree. And she also has the courage to put this in her actual written dissents, as well as to state it outright to Brett Kavanaugh's face to a room full of judges. And one of the most overlooked dissents she's written so far, I think, actually was in the second TPS case to hit the court, where she had this section that was almost like a fourth wall breaking, like meta, because she said, my colleagues have now essentially overruled the, quote, reasoned and thoughtful written opinions of the lower courts that had found Noam's removal of TPS unlawful. And she said, now my colleagues choose to, quote, wordlessly override their considered judgment, disregarding the opinion writing capacity in a rush to allow this administration to disrupt as many lives as possible as quickly as possible. So she is, in this opinion, and much as she did, I guess, during this live event, she's turning to her colleagues and saying, you are not even giving these judges the respect of explaining why you would overrule them. So this is not just about the harm that's inflicted on immigrants. That's important. That's the marquee thing in these cases, right? But she's saying you're also screwing up the entire judiciary because you're taking their, in some cases, like very long, very complex, thought out views and throwing them in the dumpster without a word of explanation why. And again, I'm just going to keep hitting this theme. They didn't do it this time, right? They could have. I thought they would have, but they actually seem to have heeded what Justice Jackson suggested, and they didn't throw the lower court's decision in the dumpster. They didn't screw over hundreds of thousands of immigrants. I think that tells us something about the efficacy of Justice Jackson's approach here.
It's funny, Mark, when I was thinking about the justices' willingness to pop off on one another and on district courts in their written opinions and not do it verbally, I was thinking it's so interesting, right? Because we've always been told, since I was a baby reporter, don't pay attention to what they say. Pay attention to what they write. Sandra Day O'Connor famously saying, it doesn't matter what we say in our speeches and, where we go around the world and say stuff. What matters is in the four corners of our opinion. And it's so interesting that in the four corners of an opinion, the justices are much more willing to take swipes at each other than they are when they're actually sitting face to face in a public setting. Then it's really, really existential to say, we all get along great. We love each other. We go to lunch. So it is doubly interesting to see a justice willing to not just say it in an opinion, but actually to say it face to face to her colleague, to a room full of judges who are thirsty for vindication, that we take seriously in a way that is completely upside down from how we are supposed to be thinking about the justice's work product, that if she's that mad that she's saying it, it's kind of for reals. I want to talk for one last second about the TPS case, because we've just been making it sound like, hey, the Trump administration is going to lose this case. And I think we should be really clear based on, as you say, the prior shadow docket opinions and based on the general posture that the majority, the conservative majority, has about Donald Trump's capricious declarations of emergencies left, right, and center. But it is still a win for something that looks like, and you've said this a couple times, real transparency. And maybe I just want to say, because our listeners are always saying, what can I do? What can I do? This is a win for people who have been pretty vocal in saying that the shadow docket is kind of gross. It makes them feel hinky, and they don't have a lot of confidence in the ways that this court makes decisions late at night, in two sentences, in unsigned orders where you don't actually know the vote all the time. So maybe this is a lever that we should really think about taking seriously, which is something has shifted.
So let me give you the bad and then I'll give you the good. The bad is that if I were a betting person, I would say that the court is still going to allow for the Trump administration to revoke TPS prematurely. I don't think that it should, but based on those earlier shadow docket orders, it seems probable. And I think what the court will say is that because the statute bars judicial review of a secretary's decision not to renew TPS designations, then it implicitly also bars judicial review of a secretary's decision to prematurely vacate TPS designations. Again, that is wrong because they don't even have the power to prematurely revoke TPS designations. This is a rewrite of the statute, but it seems to be the rewrite that conservative judges are landing on, and I fear that will win over a majority of the court. But here's the good. They're going to have to actually explain that view now. They can't just pass it off in a one-sentence order handed down at midnight. They're going to have to go to oral arguments, talk about it in open court, go to conference, argue about it at conference, do the actual opinion writing process, go through and try to justify a decision that lets the Trump administration do something that federal statutes simply do not allow it to do. There is always a chance that a justice or two could change their mind during that process. It has happened before. It seems to have happened with Chief Justice Roberts in the census citizenship case. It seems to have happened with him as well in the first Obamacare case. Like, minds are changed with deliberation. And I think that that is one of the points that the liberal justices make when they highlight the lack of deliberation in these shadow docket cases. The talk about fourth wall breaking, they've recently informed us for the first time that shadow docket cases don't even get discussed at conference as a matter of course. And so when the justices are telling hundreds of thousands of immigrants, oh, you've been revoked of TPS, good luck out there, they haven't even met to discuss that. They're just registering their votes like maybe over email, maybe over a conference call, but as far as we can tell, there is no interchange. Like, Brett Kavanaugh doesn't have to hear Ketanji Brown Jackson explain all the reasons why this is illegal, or at least all the reasons why immigrants would face irreparable harm by allowing this to happen immediately, and the government needs to cool its jets. The conservatives get to isolate themselves and insulate themselves from the other side's arguments, and I think that is extremely unhealthy, and I think it leads them to bad decision-making. Now, will it lead them here to good decision-making because they are finally hearing arguments and getting full briefing and talking about it at conference? Probably not. But again, it is a win in the procedural and deliberative sense that the court will be acting like a court, which is something that it's kind of forgotten how to do since Trump returned to office, arguably before then. And it's a win in that I think it does at least somewhat increase the odds that the court will come to the right decision, because it won't be able to duck all of the very powerful legal arguments as to why what the Trump administration tried to do here was unlawful.
Let's pause to hear from some of our sponsors. This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Ever wonder why we make the choices we do and how to make smarter ones? Join Wharton professor Katie Milkman, an award-winning behavioral scientist and author of the best-selling book, How to Change, as she shares true stories from Nobel laureates, authors, athletes, and everyday people about why we do the things we do and how to make better choices to help avoid costly mistakes. Choiceology covers the latest research in behavioral science and dives into themes like the power of self-control, shaping your mindset for success, navigating new beginnings, and why starting over can feel so hard. Listen to Choiceology at schwab.com/podcast or wherever you listen. Markets are a white-knuckle ride right now, with even the most seasoned investors feeling nervous. The world feels more unpredictable by the day, with AI coming for your jobs and geopolitical changes killing historical alliances. It certainly makes you feel like hunkering down, trying to save, looking for ways to protect your future. Well, one way you may have forgotten about is through the right life insurance policy. You've heard of life insurance, but did you know it's cheaper than you think? And the younger you are, the cheaper it is, like double the price if you wait to buy a decade from now. That's why you should be looking for a life insurance policy today with SelectQuote. If you're new to life insurance, you're not alone. For over 40 years, SelectQuote has helped more than 2 million Americans understand their options and get the coverage they need. Over $700 billion in coverage and counting. As a broker, their mission is simple: find you the right insurance policy at the best price. And SelectQuote takes the guesswork out of finding the right life insurance policy. You don't have to sort through dozens of confusing options on your own. Instead, one of their licensed agents will find the right policy at the right price for you, comparing plans from trusted top-rated insurance companies to find a policy that fits your health, your lifestyle, your budget. They shop, you save. Life insurance is never cheaper than it is today. Get the right life insurance for you for less and save more than 50% at selectquote.com/amicus. Save more than 50% on term life insurance at selectquote.com/amicus today to get started. That's selectquote.com/amicus. More Amicus now with me and Mark Joseph Stern. Let's get to John Roberts. He also seems to have, in his own weird, twinkly, dissociative way, seems to have hit some red line. In an interview this week at Rice University in Houston, he again kind of raised the alarm about direct threats to judges. Let's listen.
How do you handle criticism of your court or your opinions today?
Well, it does come with the territory. Often, when any of us issue an opinion, there's often a dissent. Usually not, but people, most opinions or more opinions than anything else are unanimous, and that's you get used to the criticism right away, and it can very much be healthy. We don't believe that we're flawless in any way, and it's important that our decisions are subjected to scrutiny, and they are. The problem sometimes is that the criticism can move from a focus on legal analysis to personalities. And you see from all over, not just any one political perspective on it, that it's more directed in a personal way, and that, frankly, can be actually quite dangerous. Judges around the country work very hard to get it right, and if they don't, their opinions are subject to criticism. But personally directed hostility is dangerous, and it's got to stop.
And of course, Mark, he doesn't name names, and he doesn't name the one guy who just last weekend was out there trashing the members of the court who voted against him on the tariffs case. Just last weekend, Donald Trump truthing, quote, "Our country was unnecessarily ransacked," all caps, by the United States Supreme Court, which has become little more than a weaponized and unjust political organization. The sad thing is they will only get worse, exclamation mark. This predates the decision in the tariffs case. There was lots of hostility and threats because Trump, I think, knew he was going to lose the tariffs case. But name-checking justices, going after them personally, mentioning their families. So here's John Roberts yet again sweetly saying, please stop. It's bad for us. This feels like yet another round of, and Roberts, in his own quiet way, has been pushing back. So this is either sort of more ineffectual, I just think of him as like a kitten, bapping away at Donald Trump with his little paw. But maybe this is really John Roberts telling us that Trump is clearly crossing a red line, that this is not funny. And I guess my question for you, it's my question for me too, is there any reason to believe that the court is starting to realize, holy cow, we painted ourselves into a box with this guy, and now we have to live in this bed that we made ourselves over and over? Is there any reason to believe that John Roberts has had enough?
So look, this is going to sound more insulting than I mean it to, but I think that John Roberts has set the bar for himself so low that this amply clears it and deserves 5 to 6 seconds of polite applause. He seems to have a pretty obvious shtick. Okay, this is what he does. Nothing most of the time. He makes no public comments. He makes no statements, right? He keeps his head down. He does the work of the court, but he does not address what's going on in the country, which is, in this case, a sustained assault on the integrity and safety of the judiciary by the president of the United States and his allies. He says nothing. And then when it finally hits a certain point where he just can't tolerate it anymore, or he deems it to have become truly and genuinely dangerous to not just judges' lives, but to the republic, he'll say something very short, very kind of temperate and qualified, but it's the signal to all of us. I think it's supposed to be the signal that he is capital W worried, or maybe capital C concerned. And that's what he did with this interview. You know, when a justice is interviewed by a judge, as was the case here, everyone should understand the questions are generally gone over beforehand. Quite often, the justice will ask the judge to pose certain questions so that the justice has an opportunity to say something. Here, I absolutely think that the chief told this judge, his interlocutor, you know, I want to get to this issue, so make sure you prompt me on it. And he said what he had to say. What he had to say was very, very, very mild. But by his standards, it was something, right? He said it's got to stop, that the naming and shaming and specific targeting of judges, particularly by powerful and influential people, has got to stop. And that was even more than what he said about a year ago when Trump was threatening to try to impeach Judge James Boasberg, and he issued his last public statement, which was, we don't impeach judges because we disagree with them. Again, by anyone else's standards, certainly by like Justice Jackson's standards, this is weak tea. But by the chief's standards, I do think it's something, and I really do think he is trying to signal to the White House and to the public, the White House won't get it, maybe the public will, that something has gone awry, and that there is more than just the usual power struggle between the branches going on right now, that the executive branch actually seems to be trying to make judges feel unsafe when they rule against him, and that crosses a line that even the Chief Justice wants to police.
So first of all, 12 seconds of sustained applause to you, Mark, which is 8 seconds more than the Chief Justice just warranted. Listen, I totally agree. Held up against what Justice Jackson was willing to say about the consequences of going after judges, it is a fascinating case study in courage, which, by the way, is a word the Chief Justice used at that Rice event. Second of all, I just want to pause to, hand on heart, spare a thought for our younger selves. Mark, you and I, who entered this term dewy-eyed, rosy-cheeked. The term began, oh my God, this seems like 1 billion years ago, in October of 2025. And we pretty much were right out the gate with arguments in the landmark voting rights case, Louisiana versus Calais, on October 15th. And as I've noted, I am 2,000 years older than that right now. By the way, I know that you are too. We are still awaiting a decision in that case that could really unloose a whole wave of racial gerrymandering around the country that is going to make this year's redistricting arms race look like a sock-up. And we're going to talk in a second about what else is coming down this term. But can we just talk briefly about Calais? What are the stakes in this case?
Oh my God. I feel like my hairline has receded 2 inches since oral arguments in the Calais case, Dahlia. But here we are, still awaiting a decision. As you say, I mean, this could absolutely wreck the redistricting process for the rest of all time by unleashing racial gerrymandering in a bunch of states that have been held back from it by nothing more than the Voting Rights Act, by Section 2 of the Voting Rights Act, which the Supreme Court seems poised to gut or kneecap in some way. And once that happens, we will see states like Louisiana, like Florida, Georgia, go after districts that have a lot of racial minorities in them and ruthlessly carve them up, divide them to ensure that those minorities are not able to elect their representative of choice, not able to participate equally in the democratic process. States are already kind of licking their chops. Some Florida Republicans were getting ready to do it in case Calais came down early. It hasn't come down yet. So probably we can be marked safe from this Calais nuclear bomb for the 2026 election. But this will be the issue in the 2028 House races. And it's not not even like the only big, gigantic Supreme Court decision that we're awaiting as of this moment, right? So we're still awaiting a decision in the case challenging LGBTQ conversion therapy bans for minors, which exist in more than half the states. More than half the states protect gay and transgender children from conversion therapy. This case says that violates the First Amendment. I think, unfortunately, the Supreme Court will agree. We're awaiting decisions in the trans athletes case, deciding whether states can just outright ban trans athletes from participating in school sports. We're awaiting decisions in the challenges to Trump's control over independent agencies and the Federal Reserve. Two big gun cases, one challenging Hawaii's law that generally restricts carrying a gun on private property, another that asks whether drug users have a right to bear arms. And then, of course, on April 1st, the court's going to consider Trump's attack on birthright citizenship. This is one of the most consequential terms of our lifetime, but I feel like we're saying that every term now, Dahlia. Is this Groundhog Day? Do they just keep raising the stakes every single term, Dahlia? Am I wrong? Am I losing my mind?
No, every term is the term of a lifetime. And add to your list, that's not all, because this coming Monday, the court's going to hear Watson versus RNC, which is an existential challenge to mail-in voting, which might or might not be relevant given that we've got elections coming up.
Let's talk about this case because it really does drive me crazy. It marks an effort to overturn laws that count mail ballots if they arrive shortly after Election Day, usually a few days after Election Day, as long as they are postmarked or scanned by USPS on or before Election Day, which proves that they were in fact submitted by Election Day. Nearly half the states have these laws, including Texas, by the way. Some red states have them, including Mississippi. And they've enacted them for the sensible reason that it seems like your right to vote shouldn't be undercut by USPS delays entirely outside your control. Federal law does not actually say that states have to toss out mail ballots that come in after the election. It also doesn't say that they have to count them. Federal law is entirely silent on this, and the only federal statutes that govern the receipt of mail ballots explicitly defer to states' decisions about deadlines. And other than that, you can search the statutes high and low. You will not find any congressional statement about whether late arriving ballots should be counted. Plenty of Republicans in Congress have introduced legislation to try to throw out late arriving ballots. They haven't passed. So the Republican National Committee filed this suit to try to enact such a law through the courts instead of the democratic process. And of course, they shopped their case to the Fifth Circuit, which predictably declared that late arriving mail ballots are invalid in a characteristically sloppy opinion by our dear friend, Judge Andrew Oldham. This was, of course, part of his ongoing campaign for a Supreme Court seat. Judge Oldham declared that when Congress set the dates for federal elections, it implicitly demanded that all ballots be received by that date. And to reach that conclusion, he defined an election to mean the date by which ballots are received rather than the date by which voters have cast their ballots, which is sort of how the Supreme Court has always described it. Can I just briefly get into a historical footnote here? Because I think this is a court that's constantly talking about history, and this is a really important piece of the case that's kind of fallen off.
Please, Mark, will you talk about history?
Okay. Judge Oldham basically ignores this. But the key statute here was enacted in the 19th century when absentee voting was still pretty rare. The widespread use of absentee voting occurred for the first time during the Civil War, when many states allowed soldiers to vote from the field. The Constitutional Accountability Center looked into those laws passed in the 1860s, and guess what they found? A bunch of them explicitly counted absentee ballots that arrived 15 to 20 days after Election Day, including those that arrived by mail. So the only relevant history here about late arriving ballots shows that states counted them in the advent of absentee voting. And when Congress shortly thereafter enacted the law that governs when Election Day is for us, even in 2026, it said nothing about that. So there's just silence here. There is no indication that Congress wanted to throw out these ballots. There is every indication that Congress wanted to defer to the states. And yet we now have the Republican Party insisting that all of these ballots that arrive a little bit late have to be thrown out because that's what a law that doesn't exist mandates.
Excellent use of history by you and the Constitutional Accountability Center. This also really dovetails with the debate that's raging right now in Congress about the SAVE Act. This is the president's favored voting suppression bill. It's currently paralyzing the United States Senate. It's hilarious that it's being messaged as like, we have to make sure they don't vote. Like, there's just so much quiet part loud happening around the SAVE Act. And various versions of the law and amendments to the law would just outlaw late arriving ballots or voting by mail altogether. It does really feel like the GOP is just trying to sneak one version of the SAVE Act into the law, right? This is the Trojan horse, doing it by judicial fiat instead of by congressional action. And if this doesn't happen by the democratic process, it still gets to happen by virtue of the judiciary.
I think that's the best way to understand this case, right? There are all these different iterations of the SAVE Act, but the key proposals before the Senate, as you said, Dahlia, they would restrict mail voting. Some of them would ban mail voting. One amendment would address these late arriving ballots, throw them all out. Highly unlikely that any of that passes. This is all subject to the filibuster. Some Republicans want to nuke it. I don't think that's going to happen. And then this is just an effort to say, oh, well, okay, Congress couldn't get this done, so the Supreme Court will get it done, which is like exactly what conservative judges are always warning against, right? Seeking a shortcut through the judiciary when you can't win through democracy. But that's what Republicans are trying to do. Why are they trying to do it? Because right now, Democrats are much more likely to vote by mail than Republicans in many states. Donald Trump has specifically dissuaded his supporters from voting by mail. Republican mail voting has dropped. And there is some data that indicates that late arriving ballots are somewhat more likely to be Democratic than Republican. And so this is a very targeted effort to throw out disproportionately Democratic ballots that were validly cast under state laws that have been in place in some form since the 1860s. And, I think it's fairly unlikely that the Supreme Court will actually take up this offer. Some rare optimism from me. Oldham's decision from the Fifth Circuit is completely incoherent. He is one of the most reversed appeals court judges today. The justices now smack him down like multiple times every term. So I think a majority will be sensible enough to overturn him here as well. But the sad footnote is that he won't care because his opinion in this case was not about getting the law right. It was about campaigning for the Supreme Court by trying to toss out disproportionately Democratic ballots and helping the Republican Party. And there's no better way to audition for the Supreme Court than to promise Donald Trump that you will interfere with elections to help the Republican Party win. So I guess we've just come a really long way since 2020 and the big lie, when you had, federal judges lining up to smack down Donald Trump's attempt to steal the election and his false claims of voter fraud. Now we have Fifth Circuit judges trying to interfere with free and fair elections by changing the rules in a way that they have no authority to do, basically at the behest of Donald Trump, who is more or less treating them as dancing monkeys, trying to see who will dance the most so that they can secure a lifetime appointment on the most powerful court in the land so that they can continue to do his bidding for 30 years to come.
That is the question. Who is the dancingest monkey of them all? And this is the question that Mark and I repeatedly tackle in our conversations on Plus, which are, as was this one, equal parts stimulating and bone-chilling. Mark, one little piece of supplemental reading before you go. We've mentioned Judge Boasberg several times now in this episode. He's been a frequent target of the Donald Trump administration. And this last week, he was again publicly pummeled by made-for-television judge flailing, deeply strange D.C. prosecutor Jeanine Pirro. And this little contretemps is the subject of this week's Executive Dysfunction newsletter from Slate's jurisprudence team and our own incredible colleague, Shirin Ali, who's been burning the midnight oil reading about Jeanine Pirro so we don't have to. Can you tell the good people why they should click subscribe and sign up for Executive Dysfunction, please?
Yes, please subscribe. This issue is fantastic. It's a really good deep dive into Judge Boasberg's decision quashing Jeanine Pirro's subpoena of Fed Chair Jerome Powell, this, nonsense investigation claiming that Powell lied to Congress about the Fed's renovation. Judge Boasberg found that the whole thing was utterly pretextual and in bad faith. He completely smacked on Trump. It's a very satisfying reading. It made me kind of like stand up and cheer. And it's especially relevant now because on Wednesday, Powell announced that he would be staying on the Federal Reserve for at least as long as Jeanine Pirro is investigating him, which is a very, very brave move. I guess bravery is a sub-theme this week and shows that he is like the last Republican in Washington, D.C. who has not been brain poisoned by MAGA and is willing to stand on principle. So Shirin gets into all that and more in the newsletter. Everybody should go read it.
And I'm just going to note, we're going to link to the newsletter in our show notes this week. And Mark and I are going to hop on over to the plus bonus segment. But Mark, way to catch us up on the good, the bad, and the ugly, and the dancing monkeys that want to be on the court. It's always a pleasure talking to you. Thank you.
Always a pleasure, Dahlia. Thanks.
That's all for this episode of Amicus, but slide on over to the Amicus Plus Smokeless Cigar Bar for an extra serving of legal tea. Mark Joseph Stern is already there on the plush velour sofa, preparing for our staged reading of one of the worst judicial tongue lashings directed at the Bondi clown car DOJ yet. This transcript is a rich legal text. The presumption of regularity is in tatters. We are laughing through our tears. If you'd like to listen, visit slate.com/Amicus Plus to join us. Your membership supports our work, and you get loads of extras and ad-free listening and paywall-free reading at slate.com. It's a total win-win proposition. You can also subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and Spotify. Our bonus episode is available for you to listen to right now. We'll see you there. Thank you so much for listening, and thank you so much for your letters and your questions and your comments. Keep them coming. We are reachable by email at amicus@slate.com. You can find us at facebook.com/Amicus Podcast. You can also leave a comment if you're listening on Spotify or on YouTube, or rate us and review us on Apple Podcasts. Sarah Birmingham is Amicus's supervising producer. Our producer is Sophie Summergrad. Hillary Fry is Slate's editor-in-chief. Susan Matthews is executive editor. Mia Lobel is executive producer of Slate Podcasts. And Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus next week.
Over 90 of the top 100 U.S. accounting firms trust Bill to simplify and secure bill pay. That's proven financial infrastructure built on over $1 trillion of secure payments. Visit Bill.com/proven for a special offer.
Youth mental health is a complex challenge that requires comprehensive solutions. We must strengthen after-school programs. We must make digital literacy tools available in our schools. We must work with mental health professionals to support children. And we must empower mentors, educators, and parents to keep kids happy. Learn more about our commitment to finding lasting solutions at empowerourfuturecoalition.com/solutions. Paid for by the Coalition to Empower Our Future.